proceedings would indicate that any attempt at this stage to resolve the dispute by mutual discussion and mediation would be an empty formality. Now, relying upon this decision, several judgments of Delhi High Court are. The second judgment which I would be referring to is the Visa International versus Continental Resources, paragraph 38. It is at page number 18 of this compilation. The discussion is whether invocation of Article 6 providing for arbitration is premature. It was contended that pre-arbitral condition for amicable settlement of the dispute between the parties has not been exhausted, and therefore the application seeking appointment is premature from the correspondences exchanged between the parties. Of the book, it is clear that there was no scope for amicable settlement, for both the parties have taken rigid stand making allegations against each other. Then paragraph 39, the portion which has been reproduced, a dispute means there may be a difference of opinion as to the future performance of the contract. For example, one party may be denying that any further performance is due on the ground that the contract has been discharged by repudiation or frustration, or it may be a common ground that the contract is subsisting, but the parties may, in a dispute about whether a particular act would constitute a valid performance or whether one party is entitled to give a particular order or exercise an option in a particular way, if the parties stand their ground. In such a situation, a time will come when it is too late for the right view to prevail. One party will irresistibly be in wrong and the serious financial losses is likely to ensue. All this can be prevented if the parties can mount arbitration with sufficient speed to enable them to know the true position under the contract before the term of the performance has actually expired. Now, paragraph 41, it is amply clear from the facts as pleaded, as well as from the exchanges of correspondences between the parties, that there has been any satisfactory recorded by the parties with respect to their claims. There has been mutual satisfaction arrived at between the parties as regards to the dispute in hand. The claims are obviously not barred by limitation. It is thus clear that there is a live issue subsisting between the parties requiring its resolution. In the light of the aforesaid, the court has appointed the arbitrator. Now, the third judgment, my lord, which I would be referring to is Ravindra Kumar Verma versus BPTP Limited, which starts from page number 34 of my compilation. Paragraph 7, 8, 10, and 11 are relevant. Others, I will take my lords to page number 40. I will be reading from the fourth line. Therefore, if the precondition of mutual discussion is treated as mandatory, valuable rights of getting disputes decided by arbitration will get extinguished, and which is not a position which should be acceptable in law. Any doubt on the aspect as to whether conciliation proceedings are required by arbitration clause are directly or mandatory is removed when we refer to section 77 of the Arbitration and Conciliation Act. Now, for a moment, I may take my lords to section 77 of the Arbitration and Conciliation Act, which talks about resort to arbitral or judicial proceedings. It says, the parties shall not initiate during the conciliation proceedings any arbitral or judicial proceedings in respect of a dispute that is the subject matter of the conciliation proceedings, except that a party may initiate arbitral or judicial proceedings where, in his opinion, such proceedings are necessary for preserving his rights.
So, the present petition has been filed.
Minutes, if I may submit for a moment, minutes. And as regards to their objection for works contract, I will just quickly take my lords to clause number 7.15, which is at page number 38 of my petition. जो ये स्ट्रक्चर की बात कर रहे हैं, वो स्ट्रक्चर क्या किया है? 7.14 talks about what is permitted under the agreement. It says that service provider will be authorized to make changes in fittings, cables, etc. as per the requirement of operating equipment with written permission from the hospital administration. And the next clause, structural modification will not be permitted. So the agreement itself says so. And recently I am referring to one of the decisions which my lord has passed on 10th of February, wherein under an identical case was dealt by my lord, wherein a similar objection was taken, wherein my lord was of the view that such contract will not be a works contract. It was simply an operation and management of a convention center.
Yes, what you were saying?
If Melons can kindly have a perusal of page 36, that is the agreement. Melons, clause 5 says period of contract. But initially, period of contract shall be for 7 years for the date of signing.
We are not deciding the dispute.
Melons, I'm not on that part, Melons. Now, Melons, what they say is that the draft, that the agreement was initially for a period of 10 years. On page 60, Melons.
That we are not expected to see all this.
My lord.
In level 6.
Melons, if I.
Why you are pointing out the merits of the case?
My lord, Melons, kindly. Melons.
They say 10, you say 7, then it's a dispute.
It is a dispute. Melons, we just have.
अगर आप भी 10 कह रहे थे फिर तो arbitration में भेजने की जरूरत ही नहीं थी.
Melons, if Melons may kindly have a perusal of reference number 9. That is the judgment of Honorable Karnataka High Court, Melons. The Honorable Chief Justice M.S. Shobha Limited versus Nava Vishwa Shashi Vijaya. Melons, may kindly come to para 10. That is page number 8. First, may I read it? It's clear from the material of records that the dispute, particularly concerning the Bangalore property, as arising between the parties in relation to the aforesaid work order. A bare perusal of the aforesaid clause make it manifestly clear that the parties have mutually made an arrangement to initiate conciliation to resolve the dispute, and if differences were still there, unresolved after the stage of conciliation, the dispute was agreed to be referred to arbitration. Then in part 3 of the 1966 deals with the conciliation, section 61 provides the application and scope in the party. And thereafter, section 62 speaks about the commencement of conciliation proceedings, which provide that the party initiating conciliation shall send to the other party a written invitation to conciliate under part 3. Briefly identifying the subject of the dispute in the conciliation proceedings shall commence when the other party accepts in writing the invitation of conciliation. In the other party rejects the invitation, then there will be no conciliation proceedings. The conciliator provided guidance as provided under section 67 of the Act 1966, which is to only assess the parties in an independent and impartial manner to reach a conciliatory settlement of their dispute. Under section 73,
I consider that
thereafter, para 12, 13, the Honorable Chief Justice has considered the judgment of SPB court.
Do you need to every time stress on who has passed the judgment? You can simply say Karnataka High Court.
It's Karnataka Melons. In para 14, Melons have considered the judgment of SPB Company versus Patel Engineering Limited, and in fact, judgments are not taken into consideration. Section 77 of the
present petition has been filed for appointment of arbitrator for the disputes arising between the parties, or adjudication of disputes arising between the parties in relation to contract executed between the petitioner on one side and the respondent on other side for the work of setting up, operation, management and maintenance of CT and MRI diagnostic facilities at Hamidia Hospital associated to Gandhi Medical College, Bhopal. Point. Next. The counsel for the petitioner has submitted that various disputes have arose between the parties in relation to payment to be made to the petitioner under the terms of contract and as to the tenure of the contract, inasmuch the petitioner contends that the tenure has been extended to 10 years, whereas the respondent has denied such extension to have taken place. And it is the case of respondent that the validity of the contract period is only 7 years, as was initially provided in the contract agreement. Point. Therefore, disputes have arisen which need to be adjudicated by arbitrator, and there is an arbitration clause in the agreement which is in the following terms. Which is the arbitration clause?
It's 10.6. 10.6.
10.6. इसका 10.6 कोट करिएगा. ये है page
42 and 43.
Next, per contra, it is contended by counsel for the respondent that though there is an arbitration clause, but it is not an unqualified arbitration clause, but it is qualified by conciliation, because it has been provided that in case of any dispute or difference, the same shall be resolved initially by mutual discussion and conciliation. But in the event of failure, it shall be referred to arbitrator. In the place of arbitration shall be at Bhopal. Point. It is therefore contended that the prerequisite of the conciliation under the arbitration clause has not been carried out and the application is premature. Point. Second objection is taken that as per judgment of the Honorable Supreme Court in case of so versus so 2018 volume 10 SCC 826, any dispute of any kind concerning works contract of the state government, the jurisdiction would lie only before the tribunal constituted under MP Madhyastham Adhikaran Adhiniyam 1983, and therefore